Welcome to our YouTube channel. We today see the Clat 2000 Common Law Entrance Test of 2000. याच्यामध्ये आपण लीगल कॉन्सेप्ट पार्ट फर्स्ट बनवणार आहोत. हे चॅनल क्रिएट केलेलं आहे ॲडव्होकेट माधवी लावण, राजेश पवार सर आणि ॲडव्होकेट महेश देवलेकर. We see the legal concept. Abstract of title. A chronological summary of all official records and recorded documents affecting the title to a parcel of real property. Acceptance. Acceptance is an act or implication that provides an acceptance and offer which then forms a binding contract in legal terms. When someone accepts an offering, they are agreeing to comply with the terms मेड इन द ऑफर. ऍक्सेप्टन्स म्हणजे एखादी गोष्ट आपण ऍक्सेप्ट करतो, त्यानंतर त्याच्यामध्ये कॉन्ट्रॅक्ट होतं, म्हणजे त्याच्यामध्ये करार होतो. ऍक्सेप्टन्स म्हणजे एखाद्याने ऑफर केली पाहिजे. समजा मी महेशला 100 रुपये दिले, त्यानं ते 100 रुपये स्वीकारले, यालाच ऍक्सेप्टन्स असं म्हणलं जातं. अकम्प्लायन्स. A partner in a crime, a person who knowingly and voluntarily participates with another in a criminal activity. Accomplice म्हणजे की जेव्हा एखादा गुन्हा करायचा असतो, ते तो गुन्हा दो दोघं मिळून करतात. म्हणजे संजय आणि रवी या दोघांनी मिळून जर एखादी बँक लुटली तर तर त्यांनी क्राईम केलेलं आहे आणि एकमेकांचे ते पार्टनर आहेत, याला अकम्प्लायन्स असं म्हणतात. ॲक्रिशन. इन्क्रीज ऑफ प्रॉपर्टी बाय ग्रॅज्युअल नॅचरल ॲडिशन as of land by alien. Acknowledgement. Acknowledgement, a formal declaration before an authorized official by the person who executed an instrument that it is his free act and deed. The certificate of the official on such instrument attesting that it was so acknowledged. Acquittal. Acquitted used as a noun in criminal law dictionary, meaning an accused person is not guilty of the crime is he is charged with. Once the acquittal is reached, the defendant may not be prosecuted again for the same criminal act or transaction. ऍक्विटल म्हणजे थोडक्यात काय, एखाद्या आरोपीवर केस केली जाते, केस केल्यानंतर त्याचा इव्हिडन्स वगैरे आर्ग्युमेंट होतं, नंतर जजमेंट होतं. या जजमेंट मध्ये जर कोर्टानं त्याला मुक्त केलं असेल तर त्याला ऍक्विटल असं म्हणतात. ऍक्शन केस. कॉज सूट और कॉन्ट्रोवर्सी disputed or contested before a court of justice. Adjective law. Also procedural law, that body of law which governs the process of protecting the rights under सबस्टॅन्सिव्ह लॉ. ऍडजेक्टिव्ह लॉ म्हणजे काय, प्रोसिजरल लॉ. सिव्हिल प्रोसिजर कोड, क्रिमिनल प्रोसिजर कोड यांना प्रोसिजरल लॉ, कारण ते का कोर्टाची प्रोसिजर काय आहे हे सांगितले जाते. Adjudication. Giving or pronouncing a judgment or decree, also the judgment given. Administrative. Administrative agencies created by the legislative branch of government to administer laws pertaining to specific areas such as taxes, transportation, and labor. Administrator, one who administers the estate of a person who dies without a will, a court officer. Admissible evidence, evidence that can be legally and properly introduced in a civil or criminal trial. ऍडमिसिबल एव्हिडन्स म्हणजे की जेव्हा कोर्टाने एव्हिडन्स दाखल केला जातो, कागदपत्र दाखल केली जातात, ती ओरिजिनल असतात, त्यावेळेस तो एव्हिडन्स ऍडमिसिबल एव्हिडन्स असं म्हणलं जातं. Adversary proceeding: one having opposing parties such as plaintiff and a defendant. Individual lawsuits brought within bankruptcy proceeding. Affidavit: a voluntary written or printed declaration of fact confirmed by oath of the party making it before a person with authority to administer the oath. Affidavit म्हणजे काय? एक शपथपत्र असतं. Affirmation: a solemn and formal declaration that an affidavit is the disease substitute for a oath in certain cases. Affirmative defense: a defense raised in responsive pleading relating a new matter as affirmative. A defense to the complaint. Defenses might include contributory negligence or stop in civil action. In criminal cases, insanity, duress, or self-defense might be used. Affirm: in a practice of appellate courts, the word means that the decision of the trial court is correct. Agreement: an agreement is a manifestation of mutual assent by two or more persons to one another. It is a meeting of the minds in a common intention and is made through offer and acceptance. An agreement can be shown from words, conduct, and in some cases even silence. म्युच्युअल कन्सेंट. ॲग्रीमेंट म्हणजे काय? एखादा करार असतो, तो करार दोघांनी मान्य केलेला असतो, त्याला ॲग्रीमेंट असं म्हणलं जातं. Aid and abet: to actively, knowingly, or intentionally assist another person in the commission or attempted commission of a crime. Align: the term align is derived from the Latin alienus, meaning stranger, foreign, belonging else. Similar terms to align in this context include foreigner and lander qualified as the citizen of the country. Align म्हणजे foreigner. Allegation: a statement of the issue in written document which a person is prepared to prove in court. Alternation: changing or making different. Alternation म्हणजे change करणे किंवा different. Alternative dispute resolution. It is very important. Is the procedure for settling dispute without litigation such as arbitration, mediation, or negotiation. ADR procedures are usually less costly and more expeditious. They are increasingly utilized in disputes that would otherwise result in litigation, including high-profile labor disputes, divorce action, and personal injury claims. One of the primary reasons parties may prefer ADR proceedings is that unlike an adversarial litigation, ADR procedures are often collaborative and allow the two parties understand each other's position. ADR also allows the parties to come up with more creative solutions that a court may not be legally allowed to impose. म्हणजे एडीआर म्हणजे काय? ऍडमिनिस्ट्रेटिव्ह डिस्प्यूट रिझोल्युशन. याच्यामध्ये दोन्ही पार्टी एकत्र येऊन एडीआर एफर्ट मेडिशन, निगोशिएशन, आर्बिट्रेशन याद्वारे मॅटर सेटल करतात. भारतामध्ये काही कंपन्या त्यांच्यामध्ये जर काही कॉन्ट्रॅक्ट वगैरे वादविवाद झाला असेल तर ते एडीआर कडे जाणं पसंत करतात, कारण का कोर्टाची प्रोसिजर ही खूप लेंथी अँड टाइम कन्झ्युमिंग असते. एडीआर प्रोसिडिंग मध्ये ही दोन्ही पार्टी एकमेकांना अंडरस्टँड करून, प्रॉब्लेम समजून, एकमेकांच्या अडचणी समजून ते त्या सॉल्व्ह करून घेतात. American Law Reports, a publication which reports cases from all university state jurisdiction by subject matter. Ancillary, a proceeding which is auxiliary or subordinate to another proceeding in probate a proceeding in a state where a decent owned property but was not domiciled. Annotations remark. Notes, 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 case summaries or commentaries following statute which describe interpretation of the statute. Answer to interrogatory. Interrogatory bracket, also known as request for further information, are a formal set of written questions provided by one litigant and required to be answered by an adversary in order to clarify matters of fact and help to determine in advance what facts will be presented at any trial in the case. Appeal. Appeal, a proceeding brought to a higher court to review a lower court decision. Appeal bond, a guarantee by the appealing party ensuring that court's costs will be paid. Appearance, the act of coming into court as a party to a suit either in person or through an attorney. Appendix, supplementary materials added to the end of a document. Appellate court, a court having jurisdiction to hear appeals and review a trial court's procedure. Appellees, see respondent, the party against whom an appeal is taken. अपील म्हणजे काय, ज्या पार्टीविरुद्ध अपील दाखल केला जातो त्याला अपिलीज म्हणतात. आर्बिट्रेशन, द हिअरिंग ऑफ ए डिस्प्यूट बाय अन इम्पार्शियली थर्ड पर्सन ऑर पर्सन हुज अवॉर्ड द पार्टीज ॲग्री टू ॲक्ट, म्हणजे दोन पार्टीमध्ये डिस्प्यूट झालेला असतो ते थर्ड पार्टीला, थर्ड व्यक्तीला तो डिस्प्यूट घेऊन जातात आणि ते तो डिस्प्यूट इम्पार्शियल म्हणजे कोणताही पूर्वग्रह किंवा कोणाची साईड न घेता की तो डिसाईड केला जातो, अवॉर्ड पास केलं जातं, त्याला ते आर्बिट्रेशन असतं. आर्बिट्रेटर, a private disinterested person chosen by the parties in arbitration to hear evidence concerning the dispute and to make an award based on the evidence. Arrangement, the the hearing at which the accused is brought before the court to plead to the criminal charge in the indictment. He may plead guilty, not guilty, and where permitted, nolo contains their arrest to make into custody by legal authority. It is very important. अरेस्ट म्हणजे काय आहे, एखादा पोलीस ऑफिसर विदाउट वॉरंट एखाद्याला अरेस्ट करतो म्हणजे त्याचा ताबा घेतो. आणि काही केसेसमध्ये गंभीर गुन्ह्यामध्ये विदाउट वॉरंट सुद्धा अरेस्ट करून म्हणजे त्याला अटक करून ती न्यायालयामध्ये हजर केलं. साधारणपणे 3 वर्षापेक्षा जास्त, म्हणजे साधारणपणे सिरियस ऑफेन्स असेल तर त्या ऑफेन्स म्हणजे त्या गुन्ह्यासंबंधी पोलीस ऑफिसरला वॉरंटची गरज नाही, तो डायरेक्ट अरेस्ट करू शकतो. आणि काही सामान्य किरकोळ गुन्हे असतील तर त्याला ते कोर्टाचं वॉरंट लागतं. पण काही असे गुन्हे असतात की त्याच्यामध्ये अरेस्ट करणं जरुरी असतं, पण अरेस्ट केल्यानंतर पुढची प्रोसिजर काय, तर त्याला त्या कोर्टामध्ये हजर केलं जातं आणि त्या कोर्टामध्ये हजर केल्यानंतर ज्युडिशियल ऑफिसर मीन्स जज त्या जज समोर हजर करून की त्या न्यायालयामध्ये त्या ऑफिसर तर्फे किंवा सरकारी वकिलातर्फे सांगितलं जातं की त्या व्यक्तीला अरेस्ट करून ठेवणं जरुरीचं आहे आणि त्याची आम्हाला पोलीस कस्टडी आवश्यक आहे. आता याच्यामध्ये दोन कस्टडीचे प्रकार येतात, एक पोलीस कस्टडी आणि ज्युडिशियल कस्टडी. पोलीस कस्टडी म्हणजे की तो आरोपी पोलीस स्टेशनमध्ये रिमांडमध्ये असतो, म्हणजे पोलीस त्याला इन्क्वायरी वगैरे करू शकतात. तर न्यायाधीश साहेबांना वाटलं की त्याला पोलीस कस्टडीची काही जरूरत नाही, त्याला आपण ज्युडिशियल कस्टडी. आता ज्युडिशियल कस्टडी म्हणजे काय, त्याला जेलमध्ये ठेवलं जातं. पोलीस ऑफिसरचा संबंध तिथे येत नाही. तिथं फक्त जेलरचा संबंध येतो. Assault, the threat to inflict injury with an apparent ability to do so, also any intentional display of force that would give the victim reason to fear or expect immediate bodily harm. Assignment, the transfer to another person of any property, real or personal. Assumption of risk, a doctrine under which a person may not recover for an injury received when he has voluntarily exposed himself to be a known danger. An issue, the time in a lawsuit when the complaining party has stated their claim and the other side has responded with a denial and the matter is ready to be tried. Attachment, taking a person's property to satisfy a court order or debate. Attorney at law, an advocate, counsel, or official agent employed in preparing, managing, and trying cases in the courts. Attorney General of for India. Attorney General for India is the first law officer of the country appointed by the President and holds office during his pleasure. Attorney General of for India म्हणजे पूर्ण भारताचा तो अटॉर्नी जनरल असतो आणि ते फर्स्ट लॉ ऑफिसर असतो. Attorney, in fact, a private person bracket मध्ये who is not necessarily bracket a lawyer authorized by another to act in his or her place, either for some particular purpose as to do a specific act or for the transaction of business in general, not of legal character. This authority is confirmed by an instrument in writing and called a letter of attorney or more commonly power of attorney. All India Bar Examination to ensure that the legal profession receives the best studied talent from the rich and ever expanding talent pool of the nation is the prime concern of Bar Council of India (BCI), which is the apex supervisory body constituted for the purpose of supervising the legal profession in the country. All India Judicial Services. All India Judicial Service, the quality of the justice hinges heavily upon the ability of the judges or adjudicate effectively, efficiently, fearlessly, independently, and impartially in accordance with the law and with the objective of meeting the aims of justice. The proposal for All India Judicial Service on the lines of IAS, IPS, IFS, and other such All India services is a welcome proposal in this regard as it in a principle has the potential to raise the quality of judges of India. Attorney of record, the principal attorney in lawsuit who signs all formal documents relating to the suit. Bail, money or other security such as a bail bond provided to the court to the temporarily allow a person released from jail and assure their appearance in court. Bail bond, in an obligation signed by the accuser to secure his or her presence at the trial. This obligation means that the accused may lose money by not properly appearing for the trial, often referred to simply as a bond. Bailiff, an officer of the court responsible for keeping order and maintaining appropriate courtroom decorum and has study of the jury. Bankruptcy. Bankruptcy refers to statutes and judicial proceedings involving persons or businesses that cannot be paid their debts and seeking the assistance of the court in getting a fresh. Bar. In law, the bar is a legal profession as an institution. The term is a metonym from the line that separates the parts of a courtroom reserved for spectators and those reserved for participants in a trial such as law. बार म्हणजे काय एक रूम असते त्याच्यामध्ये वकील आणि वकिलांचे क्लायंट थांबू शकतात. बार एक्झामिनेशन. A written examination to determine if one is qualified to practice law in a particular jurisdiction. Battery. Purposely touching or applying force on another person or thing related to the person without his consent with the intention to harm the person is known as a battery. It is only considered where when there is an actual physical contact without the consent of the person to harm the person. Thank you for watching our YouTube channel. Keep with us and read and listen a lot. We are trying to provide all the material regarding the Clat examination for 2021. If you like it, share it with other your friends. Thank you for watching this YouTube channel.